name's Ken Carlson. I'm an attorney specializing in landlord-tenant law since 1980. This free consultation is brought to you by my caltenantlaw.com website. Today, we're talking about an eviction based upon your correctable violation of a lease. More specifically, we're talking about how you win an eviction that is based upon a 3-day notice to perform covenant or quit. The notice is a little confusing. It doesn't mean do it or quit doing it. A covenant is just the legal term for something that the rental agreement requires you to do or not do. A breach of contract means not complying with that. If you had breached the contract but then complied with it, you performed the covenant and cured the breach. The legal term quit just means to move out. So, a 3-day notice to perform covenant or quit simply means that you have 3 days to comply with the rental agreement or move out. It is a warning letter. Do this or I will evict you. You could probably solve the problem within 3 days and avoid the eviction. If not, the landlord has to go to court as the next step. He can't just lock you out. If he tries, you call the police or sheriff, and they will side with you. That lawsuit could last for several months or even years, and you can win or settle it. If you have an oral rental agreement, you probably wouldn't face this kind of eviction because the landlord couldn't prove that you agreed to a particular term. This kind of eviction requires a written one. They were supposed to have signed the agreement when you did and handed you a fully signed copy. A lot of times they don't do that or even give you a copy. How can you follow the contract if they don't give you a copy? You didn't memorize it. That way, they can keep you in fear of getting evicted for doing something you didn't know about. The landlord doesn't give you a copy that he signed to keep you from suing him, hiding the key evidence, his signature on the agreement. Dirty tricks start at the beginning. Since this is about violating a term of the contract, what exactly does the contract say? Nobody reads it prior to signing. There's no negotiation. If you don't sign it, you don't get the place. Some rental agreements are many pages of technical terms and details, and they expect you to just sign right there, not take 3 hours to read it. When you sign it, you legally agree to the terms, whether you read and agree to them or not. Now that they've given you a notice to comply with the rental agreement, it has become important. Tell the landlord or manager that you can hardly be blamed for breaching the contract if you don't have a copy to read. You also have the right to get a new copy in case you lost yours. If the one they give you is missing their signature, ask for one that does have it. If they refuse or say that there isn't one, you write them and keep a copy to say that you asked and how they replied, and say, quote, "I am withdrawing my offer," close quote. They won't understand, and you don't have to explain it to them if they do ask what you mean. So you know, a contract is formed by an offer, your signed agreement, and an acceptance of your offer by the landlord's signature, which is communicated to you by giving you a copy with his signature. Until the landlord gives you his signed copy, there is no contract formed on those written terms, and you can withdraw your written offer to rent on those terms. All you're left with is the implied rental agreement of X dollars per month to rent this place, nothing more. Since he's trying to evict you on the written terms of a contract that was never formed, he has no basis for the eviction. It's too late to give you a fully signed agreement after you have withdrawn your offer. Don't tell him about this. Let him think he's got you in his grasp. You used his own dirty trick against him, and now he can't evict you based upon that notice. The judge will have to tell him in that head-slapping moment that You can't breach terms of an agreement that was never formed by his tactics. You can win the case on that basis alone. This warning notice has to be on paper, not by text, email, or orally. It must identify what you need to do that is required by the rental agreement. It has to be properly served, meaning either handed to you and any subtenant, or, after trying to do that, at least posted on the door and mailed to you. It must give you 3 business days to comply. Minor as that sounds, you can win the eviction just because one of these things was not properly done. Let's look more closely at these details of why and how you win. The 3 days that you have to comply means the day of service is day 0 of 3, and it does not include weekends or legal holidays. So, if the notice was served on a Thursday before a Monday holiday, the 3 days would be Friday, Tuesday, and Wednesday. If you were away, such as on vacation, and returned to see the notice posted on the door, the 3 days runs from your actual receipt of the notice, under the case of Davidson versus Quinn. And you should immediately tell the landlord that just now you got the notice, because you were away from home. If they refuse to extend the time based on that, you should write a letter or email and keep a copy that explains that you were away and did not see the notice until you returned, so that, under Davidson versus Quinn, your 3rd day is day X. They probably will ignore your letter, but you keep a copy to show the judge. You can win the eviction because the landlord did not give you the full 3 days, even if you were not going to do it anyway. That is especially true when the eviction case itself is filed within that 3-day period. The notice has to identify what you need to do to avoid eviction, which has to be something that's in the rental agreement. It has to be clear as to what you are doing and what you need to do to correct it. A correct notice would identify the wording of the rental agreement, explaining what it is that you did or did not do, and what you need to do to comply with the agreement. That way, you can see what they're talking about, check your copy of the rental agreement, understand what the problem is, and decide what, if anything, you're going to do about it. This notice can also include a non-payment of rent. When the notice is correctly done, and you really did break the term of the lease, and you can correct it, the solution is simple. You either will or won't do it. If you do, even at the end of the 3rd day, you have complied with the warning notice and you can't be evicted. Don't just accept the landlord's word for it that this is a violation. It may not be. What is demanded of you may not be a requirement of the rental agreement at all. The little people with power who are resident managers or work at the property management company have come to believe that if they tell you to do something, it's just as good as being in the contract. They've gotten away with their bullying for so long, due to tenants being afraid of getting evicted for disobeying, that they think it is legal. It's not. They can't just make up things to boss you around. If what they're accusing you of doing is not mentioned in the rental agreement, you are not in breach, and the notice itself has no legal effect. For all the things that a landlord puts in the notice for you to obey, an eviction cannot be based upon a petty violation. It has to be a substantial thing, something important. The legal term is a material effect. Was there a financial impact on the landlord from what you did? If not, what's it to him? It's common sense, really. Dogs running loose that might bite people, or broken glass by the pool that might cause an injury, are examples of what could qualify. But things like leaving children's toys out, having visitors without the manager's permission, having a party at the pool, or not keeping your apartment neat do not. You should ask the landlord if or how he is actually harmed by what you do. If all he can say is, well, it's in the rental agreement, you have your answer. You can write a letter or email to the landlord saying that you asked that, and his only answer was that it was in the rental agreement, but he could not identify any harm to him. Unless the landlord can show that your breach had some actual economic effect on him, he cannot evict you for it. Oh, the little people with power, the minions of the landlord, are trying to keep you in fear. Requiring an actual effect on the landlord's finances sure takes the wind out of their sails. Actually, there's very little that does affect the landlord financially if you think about it. You can win this eviction just by showing that what you did was virtually harmless. Similar to that is where there's a vague statement in the rental agreement, and the landlord is saying that you're breaking it by not doing X. For example, landlords who rent a house with a yard may require the tenant to take care of the yard. What does that mean? Well, you may reasonably understand that to mean that you water and mow the lawn, and that's it. The landlord says, oh, that's not what he meant. He wanted you to pull weeds, hire a landscaper, trim the shrubs, and so forth. Why did he say so in the lease? Obviously because you wouldn't have agreed. The legal rule is that vague terms are interpreted against the landlord so long as your interpretation is reasonable. If by your interpretation you were not required to do the extra things listed in the notice, you didn't breach, and you win the case on that basis. Similar to that is where the lease provision is there, but what they're requiring you to do is not in the rental agreement. For example, the rental agreement may say that you can't make noise after 10 p.m. so as not to disturb your neighbors. That's a legitimate term tied to the landlord's duty to protect the quiet enjoyment of other tenants, making it a material breach. So, you have a nighttime pool party, and after 10 p.m. voices stay loud, that's a violation. The landlord can give you a notice saying to keep the noise down after 10 p.m., but can't say no more guests at all because that's not in the rental agreement. Only the noise is. Your rental agreement may require that you pay utilities, but if you fall behind, the landlord might send you a notice to pay the landlord that money. He can't do that because you only pay the utility company. Is there even such a provision in the rental agreement that you have to pay the landlord? Probably not. If the notice requires as a solution to the breach that you do something that the rental agreement does not require, you win the case because they can't make you do what is not required in the contract. In his habit of bossing you around, the landlord may give you a 3-day notice to do what the law makes illegal. We see this kind of thing where the landlord threatens eviction unless you pay late fees, let him come in whenever he wants, move out while he's doing construction work, or surrender other rights. It may even be in the rental agreement that you will do these things, but the law makes those contract terms illegal. The law has to control what a contract says, not the other way around. As a result, you cannot be evicted based upon a 3-day notice that requires such things. You win the case. Let's examine those more closely. The most common of these is to pay late fees. It's probably in the rental agreement that you signed, maybe even that you agree that the late fee of X dollars is a fair amount. No matter, that section of the rental agreement is itself illegal. To be legal, a late fee would have to be the amount actually lost by the landlord as the result of paying late. That is, the daily interest of about a nickel or a dime per day for the landlord using his own money to pay bills instead of your rent. That amount is easy to calculate. So, under Civil Code 1671, the late fee itself is illegal. If the 3-day notice requires you to pay a late fee, you win the case. Another illegal notice is for you to temporarily vacate the unit during planned construction work, mold remediation, and other work that by its nature requires you to be out of the unit. Your rental agreement might actually require that you move out at your own expense, and you promised you would. However, if the agreement required you to do that, Civil Code 1953 says it is illegal as a waiver of your rights under Civil Code 1954. Again, the law controls what a contract can and cannot say. Civil Code 1954 says the landlord can come in to make repairs, but cannot abuse that right. What abuse? How about turning your home into a construction zone, leaving your home filthy with construction debris and your furniture piled up in the center of the room? How about you're having to move out to incur huge hotel and restaurant bills, among other expenses, for an indefinite period of time? How about your personal property being exposed to theft and damage by the construction workers without any insurance or protection from the landlord? It happens a lot. Yep, that's a little more than coming in to fix a leaky faucet for an hour or so, isn't it? Well, that's what you can expect unless you make a special written agreement with the landlord to protect yourself from that abuse and still allow the landlord to do the work. You can refuse to let the landlord come in unless he agrees to pay for all of your hotel, meal, and incidental expenses like parking, laundry, pet lodging. You can require an extra amount just for your inconvenience. You can require him to insure your personal property from damage or theft. You could make him promise to completely clean and return the place to its condition before the work began. You can require that he waive the rent until your place is restored to its previous condition, since you couldn't use the place all that time anyway. So, if you're being evicted for not moving out, and you offered an agreement like that, you are right, and the 3-day notice is illegal as an attempted enforcement of the illegal contract term. You win the case. When the landlord rents you the place, he sells you the temporary but exclusive right to possession. By renting, you own the possession. Trespass is a violation of the right to possession, not title. Civil Code 1954 gives the landlord the very limited right to enter. It can only be for an emergency like a fire, by your permission, to make repairs, to show the property, or for a security deposit preliminary inspection. It has to be on at least 24 hours written notice, stating one of those legal reasons, setting a date and time when he's coming in, and that has to be during normal business hours. Only those 5 reasons are permitted. Don't be fooled by a landlord's form notice that gives other reasons like to inspect the premises. That's not a legal reason, and he can't come in. If necessary, you can add a chain lock on the front door to which he doesn't have the key as a means of physically keeping him out. That is not alteration that requires his consent, like changing the locks on the door would be. It's simply an addition for your personal safety against burglars and him. If in reaction to your trying to protect yourself, keeping him out, he gives you a 3-day notice to let him in, it's an illegal notice. He cannot order you to abandon your rights under Civil Code 1954 by threat of eviction. You win that eviction because his notice is illegal, and then you sue the landlord for malicious prosecution, trespass, retaliation, invasion of privacy, breach of contract, etc. Surprising as it sounds, The landlord may use the 3-day notice to prevent you from fixing his own property and punishing you for doing it. Your rental agreement may say that you can't make alterations or repairs without his prior written consent. It makes sense until you see how he misuses it. Under Civil Code 1942, you have the legal right to make repairs of uninhabitable conditions that the landlord won't fix in a reasonable time after you ask. You don't need the landlord's consent, it's the law. You then have the right to deduct that cost from your next rent check, it's the law. You can use up to 1 month's rent 2 months in a row to fix as much as you can with that money, it's the law. Well, that's the landlord's objection, because giving you a decent place to live cuts into his profits, and he won't stand for it. Letting you take that first step to repair opens the door to that rent reduction. By giving you the 3-day notice to stop making repairs to his property, he intends to scare you away from making that deduction, accepting that you're not entitled to a decent place to live. Acknowledge the landlord's dictatorial power over you, and to obey the landlord or risk homelessness. If your 3-day notice is based upon repairs that you were making under Civil Code 1942, you win the case, because you have the legal right to do that. The contract term prohibiting that is itself illegal, as is the notice. Let's not forget that the whole notice could be wrong if it wasn't you who did what they claim. It might be a neighbor who thinks that the noise or smoke is coming from your apartment, or that it was you speeding through the parking lot, not picking up after your dog or whatever. The whole story could be made up out of jealousy, or by the landlord as a way of concealing what is actually an illegal retaliatory eviction. In the city of Los Angeles, the just cause eviction laws require that the details of the date, time, place, witnesses, and circumstances have to be given in the notice itself. That kind of protection is rare in the rest of California, and the landlord is free to make up anything. But they have to prove it. If you are falsely accused, the best approach is to tell the landlord or manager that it wasn't you, and to ask for specifics about where they got this information. Putting that in writing and keeping a copy is a good idea to create the paper trail in case it comes to court. They might as well tell you, because if the witness who started it all doesn't want to get more involved, they won't come to court to testify and the landlord loses. If the landlord won't tell you the details, why not? If it was mistaken identity, they don't want to evict a good tenant and let the one causing the problem stay, right? If their information was incorrect, the landlord doesn't want to spend money to evict the wrong person, lose a trial, get sued for wrongful eviction, and then fire the manager for mishandling this, right? If the whole thing can be corrected informally without any expense to the landlord, that helps the landlord, right? If it could not have been you because you were at work at that time or whatever, why would they evict the wrong person and lose that rent? If they won't tell you anything, it's likely that this is a disguised retaliation, and you want to write them a letter saying that you asked these things and they adamantly refused to tell you because, well, it's a retaliatory eviction for your exercising some right. Bottom line, because you could show that it was probably not you, and that they refuse to identify the specifics as your letter asks because they are hiding the truth, and they can't prove what they claim when it comes to trial, you win. A special law called the Tenant Protection Act, the TPA, created a strong just cause eviction protection. Just cause eviction means that the landlord has to have and prove one of the limited reasons to evict you. If not, he can't evict you. It applies to you if the building is more than 15 years old and you have lived there at least a year, with some exceptions. Within those two criteria, it applies if there are 2 or more units on a lot and to single-family houses or condos, unless the rental agreement itself includes a special statement saying that the TPA does not apply. Your agreement probably doesn't say it. There are 2 important parts of the TPA for our purposes here. One is that, like the Boston versus Juarez case, it says that the notice to perform or quit cannot be for petty things that don't really affect the landlord. The other is that after the 3-day notice to perform quit has expired, a second notice to quit must also be given under Civil Code 1946.2c, making it 2 3-day notices. If the landlord didn't give you that second notice, you win, because he didn't complete the process. If the 3-day notice or notices expire and the landlord accepts your rent, that cancels the 3-day notice. The law calls it a waiver of the notice. It occurs even if you have not complied, and that is not what the landlord intended. Even hanging on to your payment for too long, like a couple of weeks, without returning it to you, is considered a waiver of the notice. Waiver occurs if it is so inconsistent with the notice that you reasonably understand that your tenancy continues. Accepting rent for the next rental period is inconsistent with get the hell out. Looks like he changed his mind. So, if the landlord keeps your next rent check but continues to evict you based on that 3-day notice to perform covenant or quit, you win, because acceptance of the rent waived the breach and the notice. After the notices, if the problem isn't solved, the landlord has to file an eviction case in court. That can take a long time, and there are even more ways that you could win that case. Learn about the eviction process from the other video consultations and from the free information on the caltenantlaw.com website. After stocking up on all the free information, you'll be better able to discuss the details with one of our attorneys. I hope this consultation has explained what you need to know and opened your eyes to the different ways that you can win just based upon the defects in the notice and your rights. Knowing why and how you will win turns a scary threat into a game you will come to enjoy. Really. Now you know a lot more than your landlord does. And won't that be fun? Stand strong.